The EPA has announced plans to revisit the Waters of the U.S. rule. The agency says it will align its policy with the Supreme Court's Sackett ruling in 2023, a move farmers hope will provide more clarity. Roger McEowen with the Washburn School of Law joins us now for a closer look. Thank you so much for your time, Roger. Let's start with a brief background on WOTUS and its impact on the farm sector.
Well, good to be with you, Jennifer. It has had a major impact since the creation of the concept back in the 1970s. And over that time, since then, many courts have struggled with the proper regulatory definition of the term and its scope and impact on farm and ranch land. And that's been difficult for producers to deal with and costly if you got caught up in the bureaucracy and the legal system.
Well, EPA says it will now align its policy with the Supreme Court's Sackett ruling. What all might that entail?
Well, the Sackett decision, which came down in May of 23, was a very important decision. That clarified that wetlands have to maintain a continuous surface connection to covered waters. And that was designed to provide greater clarity, or at least we thought it would provide greater clarity on wetland jurisdiction. But then you had prior guidance documents that came out by the prior administration's EPA after the court decision that sparked debate by interpreting continuous surface connection, which the court required to include connection by discrete features such as non-jurisdictional ditches to jurisdictional waters. Well, that's all changed now. What EPA is saying now is we're going to set forth a two-part test for determining the jurisdiction of adjacent wetlands. And that is that the wetland first has to be adjacent to a traditionally navigable or relatively permanent water connected to a navigable water. And then second, the wetland has to possess a continuous surface connection to a jurisdictional water such that it's difficult to distinguish where one ends and the other begins. And that clarification will remove the discrete feature standard that was previously used.
Let's talk about the next steps for rewriting the rule. What all goes into that process?
Well, EPA announced they're going to have listening sessions in March and April across the country, and then they'll write a proposed rule after that, and then they'll have a hearing on the proposed rule before they finalize the rule. So we'll see how fast they go, but there's a process that they have to go through under the Administrative Procedures Act, and that's what's next.
Gotcha. Ag groups have stated that previous inaction and vague guidelines led to unneeded litigation and delays. Have you heard from any of the farmers on their thoughts on getting an updated rule?
Well, I've talked to a few since then, and all of them are optimistic, maybe cautiously optimistic that the government's going to back out of their lives, and that's what I hear across the board. They like the government staying out of their business as much as possible, and so we'll wait to see what happens. But so far, so good.
All right, sounds good. Well, we appreciate you staying on top of all of it for us. It's definitely going to be interesting to keep an eye on and see what happens there. Roger McEowen with the Washburn School of Law, we sure appreciate you joining us.